All right, welcome everyone. If you're prepping for the Queensland bar exam or you're just starting out, you know that some tools in the legal toolbox are way more powerful than others. Well, today we are unpacking one of the big ones, the freezing order, and we're going to do it using Practice Direction 1 of 2007 as our guide. This is stuff you absolutely have to know, so let's get right into it. Okay, so picture this. You've got a great case, you're feeling confident, but then you hear a whisper. The other side is selling off property, they're emptying their bank accounts, maybe even shifting money offshore. The trial is still months away. By the time you get that win, that judgment you fought so hard for, yeah, it could be a completely worthless piece of paper. This, right here, is why a freezing order isn't just an option. It's your most critical next move. So here's the game plan. We're going to walk through the entire life of a freezing order, from start to finish. First, we'll get a handle on just how powerful it is. Then, the nuts and bolts of how you actually apply for one. We'll pull apart the order itself, see what protections the other side has, and wrap up with the really serious promises you have to make to the court. Okay, let's kick off with Section 1, the drastic remedy. And trust me, they call it that for a very good reason. This is not some everyday procedural motion. It's one of the most serious interlocutory orders a court can hand down, which is exactly why you need to understand its true purpose.
Okay, so here's the absolute number one thing you have to get about a freezing order. It is not about getting security for your claim. It's not a way for your client to jump the line in front of other creditors. Its only job is to protect the court's own process, to make sure that if and when you win, there are actually assets there to satisfy the judgment. It's about preserving the state of play. That's it.
Now, this is where it gets really interesting, and something a lot of people miss. The reach of this order is huge. Of course, you can target the respondent, the person you're actually suing. But the practice direction makes it super clear that you can also go after a third party. So think about it. A company director is siphoning off company money into their own personal account. You can get an order to freeze that personal account, even though you're not suing the director personally. The order follows the assets.
All right, Section 2. Let's get into the nitty-gritty. How do you actually walk into court and convince a judge to give you one of these? Well, you can think of this next part as the ultimate checklist for the affidavit you're going to have to write.
So if you look at paragraph 10 of the practice direction, it pretty much boils down to these 4 pillars. First, you got to show you have a good, arguable case. Second, you have to point to some specific assets. Third, and this is the big one, you need to prove a real danger that those assets are about to vanish to stop you from getting paid. A vague suspicion just won't cut it. And finally, you have to tell the judge about anyone else who might get caught in the middle, like a bank.
And listen, this is a huge ethical point, especially for anyone heading to the bar. A lot of the time, you have to make these applications ex parte. That means you go to the judge without telling the other side, because obviously you don't want to tip them off. When you do that, you have an incredibly high duty to the court of full and frank disclosure. You have to tell the judge everything, even the bad stuff, weaknesses in your case, arguments the other side might make. You mess this up, and your whole application could get thrown out. It's that serious.
Okay, Section 3. So, let's say you've done it. You've convinced the judge the order is granted. What now? What does this piece of paper actually say and do? Let's take a look at the anatomy of the standard order. The first thing you've got to understand is that while this order is unbelievably powerful, it's not a blank check. The court is always performing this careful balancing act, weighing your client's need for protection against the very real and unfair hardship it could cause the other person. And this right here is the perfect example of that. The order is always capped at a specific number. Paragraph 6 of the practice direction says you can't freeze assets worth more than the absolute maximum you could possibly win, and that includes interest and legal costs. So if your claim's worth $1.5 million, you can't just go and freeze $5 million worth of stuff. It has to be proportionate. So what exactly is an asset? Well, the definition is super broad, and that's on purpose, right? It's to stop people from playing games. The standard order makes it clear it's not just stuff in the respondent's name, it's also anything they have the power to control, even if it's technically held by someone else. We're talking houses, cars, money in a bank, the proceeds from a sale you just made. It's all on the table. Okay, so we've talked a lot about the applicant's power. Now let's flip the coin and talk about the other side of it. Section 4 is all about the respondent's rights. The law knows how disruptive these orders can be, so there are some really important built-in protections for the person on the receiving end. Now, these are the mandatory carve-outs, and for anyone studying for the bar exam, you absolutely have to have these memorized. The order can't stop someone from paying for their groceries or their mortgage. It can't stop them from hiring lawyers to fight you. And this is a big one. It can't stop a business from running its day-to-day operations. Remember, the point is to preserve assets, not to bring someone's entire life to a screeching halt. And on top of that, the respondent isn't just left high and dry. The practice direction is very clear. The order has to include a term giving the respondent liberty to apply on short notice. And believe me, if someone wants to change or get rid of a freezing order, the court treats it as super urgent. It's all about ensuring there's quick access to justice. Okay, last section. Let's talk about the applicant's side of the bargain, the undertakings. You can think of this as the price you pay for getting such a powerful order. In return for the judge's help, you, the applicant, have to make some very, very serious promises directly to the court. I mean, look at the order itself. It literally starts with these words. This is not just some legal jargon or boilerplate language. It means the entire order, the whole thing, is built on the foundation of you keeping these promises. And we need to be 100% clear on what an undertaking actually is. It's not just a casual promise. It is a solemn vow made directly to a judge. And if you break it, well, that can be treated as contempt of court. We're talking serious consequences, huge fines, or even jail time.
So this table here really lays out the big ones you're making. The most famous one is the undertaking as to damages. You are promising the court that if it turns out the order was a mistake, you'll pay for any damage it caused to anyone. You also have to promise to serve the order properly, to pay back third parties like banks for their trouble, and crucially, you promise not to use any of the private financial info you uncover for anything other than this specific case.
So, when you boil it all down, what's the big takeaway here? It's this. A freezing order is an incredibly powerful shield you can use to protect your client. But if you're gonna pick up that shield, you also have to accept the heavy sort of responsibility that comes with it. That means the duty of disclosure, the duty of fairness, and all those serious undertakings you make to the court.
And that really leaves us with one final thought, especially for all you future barristers out there. Convincing a judge to grant the order, that's just the first step. The real test of your skill and your ethics is how you handle everything that comes after. So when you find yourself in that spot, with the assets frozen and your client relieved, you have to ask yourself, are you truly prepared for the immense responsibility that you now carry?